Good evening. Good evening. Welcome. Welcome to the Notre Dame Forum. My name is Mahan Mirza. I'm teaching professor at the Keough School of Global Affairs and executive director of its Ansari Institute for Global Engagement with Religion. Tonight's event is the fifth in a six-part series on Israel-Palestine this year under the overall theme of this forum, What Do We Owe Each Other? Previous events have presented an overview of the history, grassroots efforts for a peaceful coexistence, on-the-ground perspectives from the faculty, and Catholic social teachings on Israel and Palestine. And these events can be viewed, if you missed them, on the website. Tonight's much anticipated forum centers issues of international law. What norms does it furnish concerning sovereignty, self-determination, human rights, and territory? When and how may military force be used? What avenues exist for enforcement and accountability? I've been organizing the series this year with my colleague, Professor Tzvi Novik, and you'll hear from him at the conclusion of the program, with support from the Provost's office. We extend our deepest gratitude to both the Provost, John McGreevy, and the President, Father Bob Dowd, for inviting a campus-wide conversation on this topic by making it an integral part of the prestigious Notre Dame Forum. A special thanks to the team that puts this together behind the scenes, Heather and Hannah, Josie, and Rebecca Go. Tonight's event will go for about 2 hours. The second hour will be devoted to an open and robust Q&A with the audience. For those who are in Ramadan, the time to break the fast is 8:07 p.m. So don't panic when the clock reaches the hour, and you can pick up some dates as you exit the fruit. We have a very distinguished panel chaired and moderated by our very own Mary Ellen O'Connell, Robert and Marion Short Professor of Law and Professor of International Peace Studies at the Kroc Institute for International Peace Studies at the University of Notre Dame. Her work is in the areas of international law on the use of force, international dispute resolution, and international legal theory. She is the author or editor of numerous books, including most recently, The Art of Law in the International Community from Cambridge University Press, and Self-Defense Against Non-State Actors, also from Cambridge University Press. She's held numerous positions as a distinguished visitor within the United States and in Europe. She presented the 5th annual Justice Stephen Breyer International Law Lecture at the Brookings Institution. She has served as Vice President of the American Society of International Law and chaired the International Law Association Committee on the Use of Force. Please join me in welcoming Professor Mary Ellen O'Connell.
Thank you very much, Mahan and Tzvi. Well, I have to answer this question that we've been asking ourselves on campus all year because I feel very strongly, what do we owe each other? We owe each other many things, but one is definitely to be committed to our common law. And the world's common law is international law. And I think this law, the better we understand it, the more we expect our leadership to comply with it, the happier, more flourishing our world will be. So tonight we've chosen probably the most challenging issue, certainly judged in terms of the length of time and the efforts to understand and effectively apply international law, especially the law of peace, to the conflict between Palestinian people and Israeli people. So that's what we're here to discuss tonight, what the law says about that, how we can better fulfill this obligation, this debt we owe each other to be committed to international law. I can't tell you how privileged I feel to be introducing these two colleagues. Chimène is one of my oldest friends in international law, Chimène Keitner. She is, and wait till you hear her title, she is the Martin Luther King Jr. Professor of Law at the University of California, Davis School of Law. Have people asked to buy your title, to have that? Anyway, she has also taught at the University of California, Berkeley, University of Southern California, UC Law San Francisco, and Tel Aviv University. Chimène has authored 24 books and dozens of articles, essays, and book chapters on questions surrounding the relationship among law, communities, and borders. She is a frequent contributor to two of the most widely read legal blogs, Lawfare and Just Security. In 2005, Chimène served as co-counsel with the ACLU and Human Rights First in a lawsuit against senior U.S. officials responsible for the government's torture program in Iraq and Afghanistan. She later served as the 27th Counselor on International Law in the U.S. Department of State. She has a BA from, where's your BA from?
It doesn't matter.
Harvard. Harvard. Why was I not finding it? That school in Boston. And she has a PhD from Oxford, and her JD is from Yale. I could go on much longer, but we want to get into the law. So yes. And we also have Omar Dajani. He's the Carol Olson Professor of International Law at McGeorge School of Law, University of the Pacific. Omar served as legal advisor to the Palestinian negotiating team in peace talks with Israel in 1999 and 2001, participating in the summits at Camp David and Taba. He also served as a political officer in the Office of the United Nations Special Coordinator for the Middle East Peace Process. He is currently Palestinian co-chair of the Joint Board of A Land for All, a movement advocating a confederal two-state solution for Israel-Palestine. He's published widely regarding law, conflict, and peace building in the Middle East. He is a co-editor with Asli Bali of Federalism and Decentralization in the Contemporary Middle East and North Africa. He received his BA, and I'll have no trouble with this, from Northwestern University, where I received my BA. That's a place in Chicago, a very fine city, much better than Boston. And he also earned, like Chimène, his JD at the Yale Law School. So this is how we will begin. As Mahan already said, we had conversations, dialogue around selecting three really pressing issues on this conflict that we could perhaps make some inroads into a conversation, into laying some common ground, and then seeing where some of the issues are for discussion and perhaps later for more consensus building. And we'll take turns having the main issue set out, and then a comment from our other primary speaker. We just went in alphabetical order, and then we'll have plenty of time, we hope, for Q&A. So the three issues, as Omar said, are statehood and the related topics of rights and duties of states, including state responsibilities to respect human rights and self-determination. So that's the meta issue, isn't it? It's the one behind the ongoing, the long-running, the decades-long history of dispute between these two communities. The second topic is really taking us to the now. It is the use of force, the use of terrorism, and the related areas of law, international human rights law, international humanitarian law. And then we'll answer the question that people always rightly want to know from international lawyers: why does any of it matter? Can any of it be enforced? So that'll be our third big topic. And we're just starting in alphabetical order with Omar giving us a brief overview of statehood, et cetera.
Great. Thanks so much, Mary Ellen, for the introduction. And thanks to Tzvi and Mahan for inviting us to be a part of this conversation today. I've been teaching international law for around 20 years. And, each year I begin by asking my students the way an evangelist might, whether they believe in international law, the way that people believe in ghosts or God, the way that people believe in gun control as a mission and as a reality. And I always confess at the outset that I not only believe in the mission of international law, but also believe in its influence, in its effect, and its importance. Those things are articles of faith for me. But I'll confess to you that at no other time in my life, like these last 19 months, has my faith in international law been more sorely tested. And that's not just because my background is in part Palestinian, but also because I see in so many different respects, both the mission and the influence of international law being challenged. And so I'm really grateful that we have an opportunity to explore that together. I think none of us three is ready to give up our faith, but I hope that over the course of this conversation, we'll also manage to draw in some more believers. So that said, let me start by offering a bit of a general framework, and I'll do it quite briefly. When we think about the international legal order, what we tend to refer to is a set of foundational instruments. And perhaps the most important of all of those is the United Nations Charter, the treaty that established the United Nations, but also that after the Second World War, created a set of rules that were intended to govern how states and others interact with one another, and most importantly, were intended to prevent us from returning to the horror that had marred the first half of the 20th century, 2 world wars in the space of 20 years. And so the core norms that the UN Charter sets out of that kind appear in Article 2 of the Charter, and that's where I'd like to start. Because in Article 2 of the Charter, the United Nations member states commit themselves to respect the territorial integrity and political independence of their neighbors. And that phrase, respecting the territorial integrity and political independence of their neighbors, carries within it an idea that acquiring territory by force is unlawful. You can't use violence to acquire another state's territory, period. Whether you live in the Middle East, or you live in Greenland, or you live in Ukraine. And so as we turn to Israel-Palestine, this core norm has an array of implications that are important for our discussion today. First of all, there's sometimes a conversation about whether the state of Israel has the right to exist. And you hear both its advocates and its detractors raising that question. Under international law, under Article 2 of the Charter, there is no question but that Israel, like all states, has a right to its territorial integrity and political independence, has a right to its continued existence as a state. What Article 2 does not guarantee, however, is that Israel's constitutional order, that its internal law, would commit it to remaining a Jewish state, for example. International law, moreover, includes other dimensions: human rights law, the law of occupation, the law of self-determination. And what those other areas of law commit states to is ensuring both individual rights and collective rights within their borders and across their borders. And so while one cannot challenge the right of Israel to exist, one can challenge the way Israel operates within its borders, the extent to which the way it operates and denies others, Palestinians in particular, of their right to self-determination or of their individual rights. So when we think about the reality in Israel-Palestine, 7 million Palestinians, both Muslim and Christian, and 7 million Israeli Jews spread across a space that is just slightly larger than the state of Vermont, with 5 million of those Palestinians denied the right to vote for the government that determines most of the major things in their lives. What we see is that core obligation to respect the right to self-determination and to respect human rights has been violated. Now, I want to just speak to a couple further things because we are in the business of keeping the conversation rolling, and there'll be lots of time for questions later on. So, as I've set out, when we talk about the state of Israel, it as a state has an array of rights. And the state of Israel territorially occupies around 78% of the territory that is referred to respectively as Israel and Palestine. And one thing that those of you who haven't been attending this series all year may not fully recognize is that when people talk about Israel-Palestine, very often they're referring to the same space, not one country over here and one country over there. Two peoples treat this space, cherish this space, are attached to the space as their own. So, so the state of Israel occupies about 78% of that space. The remaining 22% are the West Bank, which is called that because it is the west side, the West Bank of the Jordan River, and the Gaza Strip, which I think everyone here must be familiar with from the news. Now, the West Bank and the Gaza Strip were occupied by the state of Israel in 1967 in the context of the June War, sometimes called the Six-Day War. Happy to talk more about the circumstances in which that occurred during the question and answer, and whether that has any implications with regard to the status of the West Bank and Gaza Strip later on. But since that time, the West Bank and Gaza Strip have been, to a substantial extent, under Israel's control. Now, the West Bank during that period has been almost entirely under Israel's control. The exception to that is that beginning in 1993, Israel and the PLO entered into a series of agreements pursuant to which the PLO would delegate some of its power or some of its authority rather, and Israel would delegate some of its authority to a newly created government with kind of municipal powers called the Palestinian Authority. And this government had authority over a smattering of spaces in the West Bank, referred to as areas A and B, while Israel retained authority over the rest of the West Bank, 60% of the West Bank, which was called Area C. Now, I mention all of this because throughout this period, Israel has maintained overriding security authority over all of the West Bank and is regarded as continuing to be a military occupant in the West Bank. And what I mean by that from a legal perspective is that Israel is bound under the law of occupation, which is a part of international humanitarian law, the law governing how armed conflict is supposed to be prosecuted. Israel, as the occupying power in that space, has an array of obligations. And I'll come back to those obligations in just a moment. But I want to turn for a second before I do to the other part of what's called the occupied Palestinian territory, which is the Gaza Strip. The Gaza Strip was fully under Israeli occupation from 1967 until 2005. Beginning in 2005, Israel asserts that it brought its occupation to an end. Palestinians and most members of the international community continue to regard Gaza as occupied territory because of the scale of Israeli control over who is allowed to enter and leave Gaza, and over issues like population registry, the ability to use certain resources, such as the territorial sea and other factors. So there is a sense, not a universal view, but a broad view that the Gaza Strip remains occupied territory. And since the armed conflict that began on October 7th of 2023, Israel's control over that area is beyond doubt. Let me just say a last thing, and then I'll turn things to Chimène to take us forward. So this last summer, in the summer of 2024, the International Court of Justice, which is one of the courts that you'll be hearing about today, it is a court that was established by the United Nations Charter and by its own statute, and that is charged mainly with resolving disputes between states around matters of international law. It is the highest court in the international system, though the international system, as we may discuss further, is not very hierarchical in terms of how it organizes itself. So it's not like the Supreme Court where you can just take any matter to the ICJ. So the International Court of Justice was presented with a question by the United Nations General Assembly, and that was whether Israel's policies and practices in the occupied territory, in the West Bank in particular, had rendered its presence in that space unlawful. And the court, in sum, concluded that it had. And I want to just explain to you for a moment why. What the court did in its opinion was begin by noting that when a state occupies another territory, because, as I said earlier, it's unlawful for a state to acquire territory by force, when a state occupies another territory, it has the obligation not to take steps that involve exercising permanent control or authority over that territory. And what the International Court of Justice concluded is that an array of steps that Israel has taken, the scale of settlements that it's established in the West Bank with over 700,000 Israelis having been settled in some 270 communities established by the State of Israel across the West Bank. The court says that looks to us like a step toward annexation. The court also pointed to steps taken with regard to natural resources and with regard to infrastructure and said, in all of these respects, what we see is a state that doesn't look like it's planning to leave. And the court said, not only is this problematic in terms of the violation of Article 2 of the Charter, but this also denies Palestinians a right that all peoples have, which is their right to self-determination, a right that not only, as I said, is a right possessed by all peoples, but which in the United Nations system, the Palestinians have been understood to possess as well. So let me stop there and turn it to Chimène to take it up from there.
Well, thank you so much, Mary Ellen and Omar and everybody here. I have to apologize to folks on this side because I feel like I'm going to be turning my back to you inadvertently some of the time, but I'm delighted that you're here and I apologize in advance. And of course, you know, we could delve into all of these issues in so much more detail, and so we're counting on all of you to raise the points that you'd like us to elaborate on in questions. So this preliminary pass is really to try to just sketch out some of the basic principles. And I think you've already heard from Omar, one of the very important, not only principles, but documents that we're dealing with is the Charter of the United Nations, which constituted that international organization, you know, sort of the mother of all international organizations. And Mary Ellen and I sort of exchanged a glance when you said that the international system wasn't hierarchical, Omar, because I think we were thinking of the United Nations Security Council and the fact that there are 5 permanent members who still have a veto on that body, which is very much, which of course, you know, you wouldn't disagree
Or
with.
even that the ICJ has been positioning itself to be a Supreme Court for international law questions, and it might even be easier to get to the International Court of Justice than to the US Supreme Court.
Maybe so.
So anyway, that's why I.
Although that raises an interesting question that actually leads to kind of a second further theme, perhaps, that was implicit in your remarks, but maybe not drawn out as much as it could be, which is one of the foundation stones of international law is consent. And again, we could, you know, dive into the kind of epistemological questions about the nature of international law, and maybe we'll dabble in those today. And those of you who are interested can take some of Mary Ellen's classes at the law school. But the foundational principle of state consent goes hand in hand with this sort of Article 2 idea that Omar mentioned, that states are sovereign. And they're entitled to territorial integrity and political independence. Moreover, Article 2.7 talks about the United Nations and its obligation to refrain from interfering in the domestic affairs of states. Now, that has been somewhat eclipsed by post-World War II developments in international human rights law, but that again has been, you know, sort of founded on a very firm set of treaties to which states have consented. And so again, when we're looking at international rights and obligations, we're looking at sort of the principal actors still being states, although of course individual human beings, non-state actors of various sorts, international organizations all have their role to play. And we're looking at state consent. And so Mary Ellen, I know you're sort of painting with broad brushstrokes, but I paused a bit when you sort of talked about a conflict between the Palestinian people and the Israeli people, because I feel that we're certainly going to talk about, and Omar has alluded to, the self-determination of Palestinian people and Israeli people, or Israeli Jews. Of course, as I'm sure you've covered in other sessions, the population of Israel is you know, about 1/5 Arab and, you know, about 80% Jewish, although again, there are Druze populations and other populations and minorities in Israel. I think one of the things that we're going to agree about, and it's certainly not everyone that you would bring to speak on a panel about international law would necessarily agree about, is this notion that although perhaps in theory, the borders of the state of Israel and the borders of the state of Palestine remain to be finalized in some sort of political negotiations, the international community, by which I mean very concretely, sort of the vast majority of countries in the world, have essentially treated what we've called the 1967 borders as the borders of the state of Israel. And so when we're talking about occupation law, again, some people would say those borders are, you know, have yet to be determined by political negotiation. Others might say, you know, the state of, where is the historical evidence that there was a sovereign state of Palestine? We're talking about a part of Egypt and a part of Jordan, and how does that play in? You can absolutely read about those kinds of debates, but where I'm coming from is very much from the position that the international community has sort of consistently and with a sufficient degree of consensus and consistency recognized that essentially these borders are the ones that we're talking about when we're talking about certainly a state of Israel for Article 2.4 purposes, but also a state of Palestine. Now, as many of you know, Israel has not recognized the existence of a state of Palestine. The United States has not recognized the existence of a state of Palestine. But as we sit here in 2025, the vast majority of countries in the world have recognized the existence of a state of Palestine. And so if we take a step back, what is it that makes you a state entitled to these various prerogatives that we've been talking about? The criteria that are often enumerated are population, territory, government, and the capacity to engage in international relations. And so in 2012, the United Nations General Assembly voted to deem Palestine a non-member observer state in the United Nations. And in 2024, there was a further vote saying, well, we're just going to give you the status of a non-member state. We can't vote in the General Assembly because you're not a UN member. For that, we would need the approval, essentially the recommendation of the UN Security Council, on which, as you've heard, the 5 permanent members each hold a veto. But you're able to participate, and many of you will see statements made on behalf of the state of Palestine in various UN bodies. A tip, if you're looking to see whether the state of Palestine has ratified treaties, which you can do by looking in the UN treaty database, don't look under the letter P, look under the letter S, because its official name is, just to erase any doubt, the state of Palestine. So look alphabetically under S.
And not under T. Not under the state of
under T, under S, not right. Exactly.
Only the Netherlands is under.
And the United States, as a country that doesn't recognize, will make various statements saying, just because we're participating in this meeting doesn't mean we recognize that there is such a thing as a state of Palestine, et cetera, which goes to show the sort of nature of international law, right? Because it's based on consent, and it's also based on the sort of collective practice of states. So what are the implications? Well, for a state of Palestine to exist, again, its recognized government is the Palestinian Authority. It is not Hamas. But as we've heard, the Palestinian Authority does not have control in the Gaza Strip. Although Israel certainly controlled most, although not all, of the entries to the Gaza Strip on the eve of October 7th, it did not have any presence within the Gaza Strip, which is what has led to debates about whether or not to characterize it as occupied territory at that moment. At this moment, unfortunately, as we've all learned, there is a renewed ground presence of Israeli troops and some very disturbing, in my assessment, comments about plans to reoccupy parts of Gaza. And so that is something to watch. But the legal status of Gaza, as occupied territory or not, I think was at least reasonably contested. And in that sense, the characterization of the conflict, the armed conflict occurring in Gaza, has been sort of an armed conflict, a non-international armed conflict between Israel and Hamas, is sort of the predominant characterization. Okay, so we're talking about sovereignty, self-determination, and territory. And just as I sort of take the 1967 borders, which again, not everyone would, so too does Omar in an organization that he works with that we might hear a little bit more about later, acknowledge that this land is, that there are legitimate claims, and tell me if I'm putting words in your mouth, to this land as a homeland for two peoples, right? And so we are dealing with a situation of, in theory, irreconcilable claims of two peoples to a common homeland. And in practice, the need to figure out how people can live there with respect, with dignity, without the kinds of violence that we've been seeing on and off for so many years. So, so on the advisory opinion, which will probably be the last point I want to mention.
Do you want to move on to that use of force point?
But
make
sure, yeah. Let me
please
just
mention
mention about the advisory opinion, and then yes, thank you for prompting us to go to the next topic. So the interesting thing about the International Court of Justice is it's got two kinds of jurisdiction. So one kind of jurisdiction is consent-based. Okay, that kind of jurisdiction involves an agreement between two states to go to the International Court of Justice and have it delineate a border or resolve a dispute under a treaty. The other kind of jurisdiction is called advisory jurisdiction, in which a body like the UN General Assembly can ask the court to answer a question that will help that UN body in its work in some way. And so the 2024 advisory opinion that we heard about is of that second category. And so it's the second category of opinion where, in fact, Israel, I think, submitted a short written submission, but actually did not take advantage of the opportunity to present arguments. It felt that the question as framed sort of already implicitly contained an answer in it, and so it decided not to participate. But this means that this advisory opinion, just to think about its legal status, is certainly an authoritative decision issued by an international court that comprised of international law experts. At the same time, it doesn't have the same status as the other decisions we'll talk about shortly in a contentious case, a case between South Africa and Israel that I'm sure that you've heard about as well.
Great. I have so many questions, but I am going to be super disciplined because I can't believe how fast the time is going. Chimène, you just before getting back to the advisory opinion, you were about to talk about use of force.
Yes.
And that is the question we need to turn to now. So we have a pretty good understanding with some differences, and there might even have been another position entirely from me, but let's move on to the use of force.
All right. So as a matter of international law, under both international treaties, of which the UN Charter is a very important one, and under what we call customary international law, it's formed by the practice of states with something we call opinio juris, or the opinion, the view that what they are doing is legally required or legally prohibited. I see some of the international law students out there. Good, I'm glad you've learned your Latin in this, but we can just call it, a belief that conduct is required by law. We have laws governing both the resort to force and how military force is used once you've decided to resort to force. And for a bit more Latin, for those of you with international law aspirations, right, we have the use ad bellum, that's our use of force. I can turn it over to you in the middle there. And then the use in bello, all right, or what we call sometimes international humanitarian law. So, I'm going to narrow down, although of course these bodies of law exist all the time. Narrow down on October 7th and its aftermath in terms of the application of these bodies of law. And excuse me, I don't need to remind you that on October 7th, as Omar has set out with colleagues in very compelling presentations that you can also find online. We had the deadliest per capita terrorist attack that the world has seen. There were 1,200 deaths in Israel, as you say, a tiny country, 251 hostages taken. It would have been analogous to a 9/11 on which close to 50,000 Americans were killed, or people were killed on American soil, because of course, not all of those killed or captured were Jewish. At the same time, sitting here in 2025, we also have credible figures of over 50,000 deaths in Gaza. Again, those figures, like the Israeli figures, don't distinguish between civilians and combatants, but the human toll of the last 19 months has been breathtaking and abominable, and is like, I will say, Russia's invasion of Ukraine, a situation that has made we international lawyers, even though we've always been cautious about trumpeting the successes of the international system, given that there are deep inequalities, and there were even before these two events, the constraining force of international law didn't constrain Hamas from launching its attack. We can talk about the extent to which it's constrained Israel in its response, certainly has not constrained Russia. So in terms of the decision to use force to begin with, I'll deal with that very briefly. As everyone probably knows, the legal basis that Israel has cited for its use of military force is self-defense. I'd like to dig down a little bit more into permissible uses of force. And the guiding principles for the use of military force include what we call necessity, proportion, precaution, and distinction. Again, each of which we could talk about for much longer than we have. But I think that some of the key criticisms of the Israeli military response have related to questions about the extent to which it has observed the principle of proportionality. Proportionality doesn't mean, you inflict upon the adversary the same amount of damage they've inflicted upon you. What proportionality means in the international humanitarian law context is when you are targeting a particular building or individual, the expected, what we unfortunately call collateral damage, the damage to civilian life or objects, can't be disproportionate to the concrete and direct military advantage expected from the attack. So to a certain extent, as outside observers, it's difficult to assess on an attack by attack basis whether the principle of proportionality was complied with unless we know what was the concrete and direct military advantage expected. At the same time, when we look at the degree of devastation in Gaza, it's very hard to imagine that those who were engaging in targeting decisions were following the concept of proportionality as generally understood by international lawyers. And certainly when you look at the effect of the attacks cumulatively, it's very difficult to understand what kind of proportionality rationale consistent with international humanitarian law has been followed. Again, looking now at 19 months of military activity with small break for the ceasefire. Similarly, there is this principle of distinction, that attacks must distinguish between, and some people call it a principle of discrimination in the US Army. Distinction is you must distinguish between military objectives and civilian objectives. So here's the challenge. If you are in the Israeli army charged with defending Israel, there are going to be people in the room who will say, Hamas is embedded in tunnels underneath the civilian infrastructure. How do you expect us to rescue hostages who are trapped in tunnels or demilitarize Hamas without damage to the civilian infrastructure that is sitting on top of the tunnels? They will say, there are Hamas operatives in this hospital. How do you expect us to achieve the legitimate military objective of targeting these Hamas operatives? And when I say operatives, I should say combatants, to be clear, not mere members of a particular political party. How do you expect us to do that without severe civilian collateral damage? But the problem is, I think, especially the day after or the week after or 2 weeks after something like October 7th, it's very hard to overcome those voices in the room, right? When a country is feeling under siege. At the same time, for law to play the role that Mary Ellen started us off with, at a certain point, it's imperative to push back on those voices in the room. And I think both in the Israeli establishment, certainly in the US establishment, that's a more difficult thing to do than some of us sitting here can imagine. And that's something that I welcome and encourage all of you to sort of think about in this moment, both with respect to the conflict that we're talking about and with respect to other conflicts that we might be engaged in or see in the future. The final thing I'll say in this little roundup is we're going to talk about enforcement in the next segment. And I'll talk a bit about the International Court of Justice and the International Criminal Court. The rules that those courts have been asked to enforce in this context involve both IHL, international humanitarian law. So there's allegations of war crimes, violations of those principles of distinction, proportionality. There are alleged crimes against humanity. A crime against humanity, the distinguishing feature is that it's part of a widespread or systematic attack on a civilian population. And again, those war crimes, crimes against humanity allegations go both to actions by Hamas and actions by the Israeli armed forces. And then there's also, as I understand, there's been great interest in the room in sort of previous iterations of this series, the allegation of genocide. And so we can take up the elements of the crime of genocide, which is a crime for which there is state responsibility. So a state can be responsible for genocide, but also individual officials can be responsible for genocide. And as you've probably heard, what is required to make a finding of genocide, as opposed to, in my view, an equally serious allegation of a war crime or a crime against humanity, is that the actions taken or not taken, in the case of, for example, withholding humanitarian aid, must be targeting a particular kind of group. And here the Palestinian people have been, and the Palestinians in Gaza in particular, have been determined to qualify as such a group. And they must be taken with the intent to destroy that group in whole or in part. And so to the extent that there's legal disputes about genocide, that's really where the disputes are. It's about that intent requirement, which is unique to the crime of genocide, notwithstanding what we would say the actus reus of widespread killing and widespread civilian deaths that I don't think anybody, that actus reus, nobody disputes.
Before we move on to Omar's response, would you just touch on, so you mentioned that Israel's basis for justification, so Israel is definitely invoking international law. It's not moved to some post-international law position. Self-defense being the primary reason that the airstrikes began and then the ground operations in Gaza. Is there a claim of justification for what the armed wing of Hamas did and other Palestinian armed groups on October 7th? I mean,
not a claim that I'm aware of. I know that there have been by Hamas, and again, I don't read Arabic, so I'll stand to be corrected by those who do. I think there have been attempts at post hoc justifications, and I don't know, maybe Omar, you want to pick up with that?
Yeah, happy to.
Okay, go ahead.
I'll circle back to it in just a minute if I may.
Start where you had planned.
All right, great. So I want to turn to the bodies of law that Chimène raised, and in a moment to highlight what I think is the majority of areas where the two of us are in sharp agreement, and also to identify areas where there may be some disagreement. But I want to start off by saying something that I think is demanded by the political moment that we are facing in this country right now. We are dealing with a reality in which advocacy of Palestinian rights is very often conflated with support for Hamas as a general matter or support for Hamas's actions in relation to terrorism, which I think is a both dishonest and dangerous move for our government and government officials to take. And I think that it can have a very chilling effect on conversations of this kind. Luckily, the three of us are citizens of the United States, but I want to stress how fraught things are, and that if I weren't a citizen of the United States, I would be afraid about responding to some of these questions honestly. And I think that we've got to grapple with where we've arrived as we try to have this conversation today.
And Omar, I just want to, underscore that 1,000 times. If there's anything this country is supposed to stand for, it's the freedom of speech. And so that's a point we should all be
and I think
rallying
we
behind.
very much see these things in the same way.
And in our discussion on enforcement, there is what we might call soft enforcement. The price the US pays for not protecting our freedom of speech is that we are beginning to pay a reputational price, which has knock-on effects in terms of our economy and our own security by not holding fast to the authentic rule of law. I didn't mean to interrupt.
Absolutely, no. And I was at the Munich Security Conference in February, and the day before I spoke, our vice president lectured, in addition to blowing a hole in the transatlantic alliance, lectured our European allies about freedom of speech in ways that I think many people find ironic in this moment. But that's we can talk more about that later. But I wanted to start off by stressing that. Now, let me start with the question that Mary Ellen raised, which is the claims of lawfulness by Hamas with regard to its actions on October 7th. And there's an important distinction that I think people need to be aware of. In international law, there is a right to resistance. So if we look at the law that speaks to when you're allowed to use force, you are allowed to use resistance against foreign domination. And that is an accepted dimension of international law. However, that right to resist is constrained by precisely the kinds of norms that Chimène was just pointing to in relation to Israel's conduct in the Gaza Strip. And so Hamas also had the obligation to, above all other obligations, distinguish between civilians and military targets. And to my mind, the most crucial violation by Hamas on October 7th of its legal obligations was its failure to distinguish between military targets, which are acceptable under the law of the law that we're invoking here, the jus ad bellum, and on the other hand, and the jus in bello for that matter, and on the other hand, killing and taking as hostages civilians.
And again, this perhaps goes without saying, but just to the extent that there are military targets, of course, that does not sanction torture, rape, hostage taking, and so forth, just because you've got
there are certain
military
absolute
target.
prohibitions.
Absolute
Those are
prohibitions, right? Yes. So as we think about Hamas's claims around October 7th, we've got to bear in mind that push and pull. And at the end of the day, look at numbers, and the numbers tell an important story on that front. Now, turning to the actions of Israel in the Gaza Strip over these last 19 months, there's so much that we can discuss. I want to just confine myself to a few things. So the first thing that I think we've really got to grapple with is these core norms that guide the jus in bello, which refers to the humanitarian law, how you operate during war. And the twin pillars, as Chimène said, are number one, distinguishing between civilians and military targets. And number two, because you are allowed to harm civilians while, so long as you are focused on military targets, ensuring that that harm is not disproportionate to the aims that you're undertaking to achieve, right? And so when we look at the scale of death and destruction in the Gaza Strip, what we see, as Chimène pointed out, is indication that both of these norms were violated. But what we can also see if we look at the coverage of specific dimensions of this, areas where I think, tell me if I'm wrong, we would agree that there are some clear violations. So if you followed, for example, the phenomenon of sniper fire directed at children, or of drone fire directed at children and others who were clearly non-combatants, that is without a doubt a violation of the requirement of distinction. And that has been a frequent phenomenon. And you can look at, don't trust me on this front, if you look at the reports of some of the leading human rights organizations, international, Palestinian, and Israeli, what you see is a lot of attention focused on that. With regard to proportionality, one thing that I'd urge you to have a look at is the excellent reporting by Yuval Abraham, an Israeli journalist, in 972, which is a website of Israeli and Palestinian journalists who produce exceptional reporting about a range of different matters. And one of the things that they have highlighted is that, that Yuval Abraham in particular highlighted, is that using artificial intelligence, Israel's targeting has really skewed the idea of proportionality beyond what had previously been contemplated as anything approaching reasonable. And so in one particular article, focusing on the first months of the war, what was found was that Israel was routinely factoring in as being okay deaths of 15 to 20 civilians for low-level targets and up to 200 civilians for high-level targets. And what's that?
The software is called Lavender, for those of you who are.
The Lavender program, exactly.
And these were sort of reverse engineered assumptions about the proportionality calculus, right? In terms of information gleaned by the journalists.
Exactly. You mean that the journalists sort of looked at what the number...
Right, like nobody said this was our proportionality calculus.
Although they do have
from
some
that.
direct information in the main 972 article that revealed this. They do have some statements from Israeli drone operators that those were the calculuses that they were. So there was some inside information in addition to observation.
Right, which raises this really tricky problem, right? And it is, and I think, as you said, Omar, in one of the first American Society of International Law webinars, they sort of had on these issues, like, if this is what proportionality looks like, IHL is not much use, right?
Right, yeah.
With which I agree.
Who gets protected?
With which I agree entirely. That said, just to sort of present the conceptualization, because proportionality doesn't come with numbers, right? It's a principle. If what you are weighing on sort of the military advantage side, and it's supposed to be concrete and direct of that particular strike, so there are some limitations. But if you put yourself in the position of thinking, rightly or wrongly, that you are weighing, the continued existence of the country, because again, Hamas has been very clear that its goal is the destruction of the state of Israel, sort of the reclamation of the land from the river to the sea. Then, right, you can see how, and I think this is, we've been talking about this concept of plausible legality, right? You can see how, 19 months out, I think it's much harder. But in the moment, my guess is that some people were making a proportionality calculation that essentially inserted the existence of the state of Israel into what needed to be countered. And that's going to trump everything, right? I mean, that is going to enable essentially the justification from an Israeli perspective of these kinds of, what to our ears sound like, extraordinarily disproportionate civilian casualties and destruction of civilian objects.
We're getting very short on time.
Yes.
And I'll just say for Israel, Israel's not the country that came up with this entire mission, the defensive mission. is what you compare to the individual deaths. The US did in Kosovo. That became part of our US doctrine. So, but why don't you take two more minutes?
Okay,
And
sure.
it'll be very brief on enforcement.
Yeah,
Because
sure.
we have really talked about enforcement a bit, but please, Omar, finish your
Okay, I'll be.
Although I thought that was a very helpful colloquy.
And I would just add one
Yeah, please.
small thing to that, which is that I agree that that is how I imagine that Israeli planners, military planners see it. But I think that one also has to reasonably look at the massive asymmetry in power in assessing whether characterizing what Hamas was capable of as an existential threat to by far the most powerful military in the region is credible. And I think that for many Palestinians, they scratch their head at that kind of calculation.
Would you also, in addition to, we've talked a lot about targeting, but people are aware that Israel has used other tactics, which I think you can't fit in to international humanitarian law at all, withholding of food, medicine, entry of aid workers.
I think they would try to fit it in.
All right, how would they try to do it? I think Omar's agreeing with me that that's.
Yeah, no,
Really
and this maybe gets into a little bit the South Africa case, but I think so just to state very clearly, a complete shutoff of food, water, electricity to, a heavily civilian populated area, to my mind, is patently unlawful. All right, but I think that to the extent that there's a justification, and again, what bothers me tremendously is the recent resumption of this, because it in the first days of the war, it was complete, and then piecemeal, some of it came back, but the withholding. So the rationale is we at least have a right to inspect everything going in because Hamas is benefited by these. Hamas is the one using the electricity. Hamas is the one taking the supplies, and so on and so forth. So again, to the extent that there is a legal rationale proffered, it is this idea of providing support to the enemy, essentially, and that these things would not actually reach the civilians for whom they're intended, which comes back to occupation law, because if you're in control of the territory, it then becomes your obligation to ensure that these supplies reach the civilians.
Right. So let me just say two quick
sure.
things, and then we'll turn to the last bit.
Very briefly to enforcement.
I think that I'm on solid ground in assuming that among the three of us, there is a consensus that forcibly deporting a population from a territory, as President Trump recently advocated, as Israel's foreign minister has advocated, and as two other of Israel's cabinet ministers have regularly advocated, is patently unlawful. It violates the Fourth Geneva Convention, Article 49. It violates the Rome Statute of the International Criminal Court, and falls within that category of crimes, which we call crimes against humanity. So there's no international lawyer, I think, worth her or his salt, who is going to suggest that what was being urged in that context has any basis in law. There is a little bit more room to maneuver if you are doing it on a temporary basis from a particular area, but that's because of the factual circumstances, it's very unlikely that that's what was being urged. It's an unlikely reading. The last thing I want to say is to just come back to the issue of genocide. And I will confess that about 7 months into the 7 months after October 7th, I was taken to task by a Palestinian colleague who said to me in a public gathering, "You have not used the word genocide. How can you refrain from characterizing what is happening on the ground there as genocide?" And I, at the time, said, I think there are still some questions to be resolved about intent. I'll tell you, at this juncture, those questions have been resolved in my mind. And when I look at, in particular, the ways in which there has been systematic and intentional destruction of life-preserving infrastructure all across the Gaza Strip. The ways in which hospitals have not only been targeted because of the concern that Hamas might be present, but torn apart bit by bit, in which universities and other cultural institutions have been demolished using explosives in a very systematic way. And finally, the way in which the population has been starved over the course of this period, and I encourage you again to look at the figures with regard to what quantity of assistance actually gets in to this population. When I look at those factors together and combine it with the concerns that I raised earlier about proportionality and distinction in the use of, in the context of targeting, and the statements that we have heard over and over again from Israeli leaders, I can't see a basis for failing to use that word any longer. I'll stop there.
So we do have the case that South Africa has brought to enforce the Genocide Convention, this most serious crime that we can imagine in the human rights context. I personally believe that the unlawful use of military force is the crime of all crimes, aggression. Russia, clear case. I actually have quite different views from both Omar and Chimène as to the legal right of either of these groups to resort to military force. But I'll save those if there's time in the Q&A. I can talk about them a little bit. We do have a case at the International Court of Justice, this leading court in the international community that South Africa has brought for Israel's violations of the Genocide Convention, and that Israel has stepped up and answered. It did not avoid the court as the US did when it was charged with aggression by Nicaragua. It did not avoid the court as France did when it was charged with atmospheric nuclear testing by Australia and New Zealand. So Israel, in the scheme of things, has given respect to the International Court of Justice and come to answer this case. Will it comply with the decision of the court? Is the court? Well, that's one way we have of explicating. And remember, we're now seeing this in the United States. Courts do not command armies. They don't have much of a police force. Even the US Supreme Court, they need willing compliance, willing understanding that when this court speaks, those spoken to must comply. Is this all we have in international law? So, I mean, it's cold comfort to say the US is facing the same crisis. Russia long ago, the courts in Russia long ago gave up on trying to hold President Putin to the law. That's why it's a dictatorship. Do we have anything else?
So why don't I take a step back
Yeah.
And duck the question? Like just setting forth, again, in just a few minutes, and you'll keep us
Yeah.
to time.
Yeah,
And
we've got 3 minutes. So you can say something on this, Omar can say something, and then we're turning it over. You guys.
Oh, I talk fast as it is, but if I really have 3 minutes, I'm gonna have to speed up. So just
No, you have both have 3 minutes. You have a minute and a half.
state of play in two international courts. International Court of Justice, consent-based jurisdiction based on what? The Genocide Convention. Israel was one of the first countries to join. South Africa is also a party, has brought this claim for violations. It will be years until the court tells us whether or not it's found evidence of genocide. But what it has found, and as Mary Ellen alluded to, has issued provisional measures orders saying Palestinians have a plausible right to be protected from genocide. Israel, in the first instance, you need to allow the greater flow of humanitarian aid. Israel's position has been, up until recently, I assume, that it's complying, that it did increase the supply of aid, that it's not committing genocide because of this missing, in its view, intent element. However, I don't know how the absolute shutoff of a couple of weeks ago is squared with those provisional measures orders, notwithstanding whatever came before. International Criminal Court. Unlike the ICJ, the International Criminal Court brings cases against individuals for their individual criminal responsibility. We had 4 arrest warrants. A pretrial chamber found that 4 arrest warrants could be issued in the first instance relating to this situation. 2 of them were against Hamas leaders who have since been confirmed dead. The other 2 are for Benjamin Netanyahu, the Prime Minister of Israel, and the former Defense Minister Yoav Gallant. The ICC has jurisdiction. It can assert this jurisdiction because the state of Palestine, which again Israel does not recognize, has joined the treaty that created that court. So the United States takes the position, for example, that if your country hasn't joined the court, that court can't exercise jurisdiction over you. The court itself takes a different view. The crimes for which these individuals so far have been charged are war crimes and crimes against humanity. However, genocide is within the jurisdiction of the International Criminal Court, and that investigation is ongoing. Hopefully that wasn't more than about 2 minutes.
You did really well on 2 complicated courts, but Omar, you're gonna have, you started, you should not have the last word, but we're gonna give you the last word in this round.
Just because I'm a gender minority here. So I want to first of all stress that while the courts at the international level preoccupy us, particularly as lawyers, they are not the main enforcers of international law.
Absolutely.
Who are? States. And so
People.
And people to some extent too. And so when we think about how international law might be enforced in this context, in normal circumstance, our first address might be to knock at the door of the United Nations Security Council, which has the primary responsibility for maintaining peace and security in the international system. The problem that we have confronted in the Council is that the United States has consistently exercised its veto to shield Israel in the Council, just as Russia used its veto to shield Syria. And we are really getting close to a kind of constitutional crisis at the Council level. Absolutely. Because we've got US vis-a-vis Israel, Russia vis-a-vis Ukraine, and we'll see what happens in Taiwan this year. And so there's a lot to be worried about as far as the Council's concerned. But it seems like the Council being super effective is not something we're likely to need to worry about. And so we have to turn to in other directions. There are options for collective action by states. And the General Assembly, for example, as we saw at an earlier juncture in relation to Rhodesia and South Africa, the General Assembly can be of the United Nations the arena where decisions are taken, for example, with regard to sanctioning states, either imposing restrictions on trade with them or at least minimizing provision of arms to them. That's not a step that's yet been taken, but it may well be. We may see, instead of the entire General Assembly, or in addition to that, taking action on this front, smaller groups of states. One of the big questions is whether we will see the European Union as a whole or segments of the European Union begin to use its muscle in ways that it has hesitated to so far if this continues down the path. And then to Mary Ellen's point, there is a role for citizens as well. There has been a call for boycotts, a call for divestment from Israel. And this is one nonviolent way that citizens in a range of countries have undertaken to say, hey, we're going to try to raise the costs of the alternative to a negotiated future. Since I need to end, I'll just end by saying one of the things that we really have to grapple with as we think about the future of this place is what incentives are in place to create a different future. My great concern is that Israel at this juncture has very few incentives to shift its behavior. And I think that for that reason, we have to be thinking very hard about both carrots and sticks. I have a lot more to say about that, but I'll save it for later.
Great, I can't wait to hear about the carrots. I love carrots. We do so much more with sticks in this world, more carrots. Okay, I hope you have lots of questions. Sir, in the blue shirt. What, do you want us to, let's wait for a microphone, and why don't you briefly tell us who you are? And then we'd love to hear your question.
Paul Huber, I'm a retired faculty member here from chemistry. So,
Okay.
but I was wondering if you could talk a little bit about what protections, legal protections, there might be for the press, since the press has been pretty much forbidden to enter into Gaza. And I think at this point, the number is about 230 journalists that have been killed. And so if we can't get information out, what protections are available? I guess that's what I'm asking.
Civilians are not targetable, period. So if you're identified as a member of the press, then you are presumptively a civilian. In fact, anybody is presumptively a civilian. So that status is presumed, which is supposed to operate as a protection. Now,
the Geneva Conventions actually single out members of the media for special statement that they are never targetable. They are, right. We were just setting out what the rule is. They should be protected. They need to wear visible vests that show their press. But
so where the factual, so the legal rule is clear. Where the factual disputes might arise, right, are the extent to which they are lawful collateral damage. And again, as I think we've more than suggested here, we would have a very different calculus than it appears the Israeli government has been using for what is permissible collateral damage. In terms of of barring entry, again, I think that's largely been done in the name of protecting civilians. That's also the rubric under which we've seen mass population transfers even within Gaza, right? We're getting you out of the area of intense hostilities so you won't be caught in the crossfire. I think that, as Omar was saying, some of us who watch the region were perhaps more inclined to give Israeli authorities the benefit of the doubt at the very outset of this. And that willingness is certainly, at least in my case, worn very thin. We didn't talk a lot in this panel yet anyway about domestic Israeli politics, but those of you who've been following them, I think there really is a sense in which a lot of these restrictions are not being enforced. The JAG officer, the military advocate general, has brought a number of charges against Israeli soldiers in Israel for law of war violations. She's under siege for having done even that. So I do think we have a culture of impunity at the moment within the military that is making those sorts of rules much more difficult to enforce than they should be.
I think it's really important that there's been new peace activism in Israel, anti-Netanyahu, pro-rule of law. Maybe more aimed at the so-called reforms for the judiciary, but I think any popular movement toward commitment to the rule of law has a ripple effect. I see the US's own failure to comply with international law on the use of force has come back to haunt us, where we don't have the same respect in general for life, for the rule of law. But even more heartening, perhaps, has been the pro-peace activism just today, in the last 24 hours in Gaza. People, the human beings involved, are beginning to see that this is so pointless and it's almost impossible to comply with this law. The thing that's always possible is not to kill.
If I could just add one thing on the issue of journalists. So I think one of the disturbing realities has been that not only have journalists been sometimes killed in the context of targeting military targets, and so there are these proportionality issues, but they've also been directly targeted. And so Bassam Shamat, who was killed just earlier this week in a missile attack on his car, is a young Palestinian journalist for Al Jazeera. No evidence whatsoever has been proffered that he was, at the time of being assassinated, engaged in any kind of military conflict with Israeli forces or against Israel. The IDF, Israel's army, does claim that he at some point in the past was a Hamas sniper. But what's important to bear in mind is that of course, they haven't offered evidence for this. But even if he was at some point in the past in playing a military role, that does not give Israel authority under the law to
the
take
law
him
is
out
clear.
front. Yeah.
For such time as civilians who enter into fighting, and I wouldn't call them combatants, Chimène, I'd call them fighters, because combatants is a term for a lawful member of the armed forces who has the right to engage in armed conflict. But a fighter who is participating, of course, can be targeted. When they step out and they're in their civilian life, they are no longer targetable. The rule is for such time as they are participating as a fighter in the conflict, they may be targeted. Now, Israel and the US have tried to weaken that rule, but the rest of the international community, and it's quite deep in the culture of our militaries, that you do not target somebody who is not in the status of a fighter at the time. How do you know who's a civilian and who's not, except when they are actually participating in the fighting? But anyway.
No,
so,
and maybe just to your point,
Yeah.
and to return back to questions, of course, but about the United States and our role, right?
we have to have very
Because Omar, as you were saying, absent the Security Council, it's really about, states, and there's so much we could say about the lack of a constructive role that the United States has played here. But I'll highlight one aspect of that, which is, statements made by our current Secretary of Defense, and the fact that one of the first things he did upon assuming office was essentially fire, as I understand it, most of the JAG Corps, so which are the attorneys who are charged with ensuring our compliance with the laws of war, right? So one of the things that I would like to see is the United States leading by example, and this is by no means the first time that we haven't, as Mary Ellen has pointed out. But I think it's extraordinarily important that we also advocate domestically for adherence to the rules of international and domestic law if we are going to expect other countries in the world to follow them as well.
More questions? All the way in the back, the gentleman in the plaid jacket. Yeah, and stripes.
This is more specifically for Professor Dajani, but I heard it mentioned in the beginning that you're supportive of the idea that a confederal state of both Jewish and Arab elements should exist in the area. And I believe that too, but the question I have is, to what extent do you think other peace agreements, like the Good Friday Agreement in Northern Ireland, which deals with a similar situation, can be applied to the situation in Palestine and Israel?
That's such a good question. So I do believe in a two-state confederation where a Palestinian state would be established alongside Israel, and the two states would be connected together in a confederal union, meaning that it wouldn't be one state, but they would have some shared institutions, and the border between them, as in the Schengen area in Europe, as like the border between the UK and Ireland, like the border between Australia and New Zealand, the Mercosur states in South America, the border would be one over which people could move freely, even if it were regulated. So that's the background to the idea. And if anyone is interested in how this might work in Israel-Palestine, have a look to Google a land for all Israel-Palestine, and you'll see the vision of the movement that I've been very involved with, and which we're trying to elaborate. I think that the experience in Northern Ireland is instructive in a lot of ways. I'll just point to two. So the first may not be exactly where your question is headed, but it does, to my mind, really pertain to the issue of incentives. Prior to the mid-1980s, the Unionists, the Protestants in Northern Ireland, had very little incentive for engaging in peace talks with the Catholics. Why? Because the default option was always direct rule by the UK, which is what they wanted. So why engage in negotiations if when everything collapsed, you'd always go back to direct rule. In 1985, the UK and the Republic of Ireland concluded an agreement that changed the default option so that suddenly it was no longer direct rule. Instead, it was going to be arrangements in which the Republic of Ireland had to stay. And so that really altered the incentives of the unionists in ways that would only be felt 10 years down the line. And that's one of the things that we really have to start thinking about in Israel-Palestine is how do we alter incentives so that the current trajectory no longer is interesting. But I think, so the second thing I'd say is that one way in which I think there is a real difference between the approach that was taken to Northern Ireland and what we need to be doing in Israel-Palestine is that in Northern Ireland, there was an embrace of constructive ambiguity. So the ultimate fate of Northern Ireland is shrouded in obscurity. And that's part of the way a deal was reached. And that was possible because UK at the time and Ireland were both parts of the European Union. So there was this normative framework that ensured a lot of protection for everyone who was involved in the conflict. And there was a human rights court that had authority over a range of important questions pertinent to the conflict. We lack that structure in Israel-Palestine, which is one of the reasons why, to my mind, it's so crucial that our endpoint actually be clearly defined. For too long in Israel-Palestine, we've had a transitional process without knowing what we were making a transition from or to, and that only strengthened opponents of peace. And that's one way in which it's different. But I'd be happy after the talk to chat with you further about some of the other similarities and differences between the two situations.
Let's get another question. I'm not seeing any women raising their hands, but that's fine. You, sir. Yes. Wait for the microphone. Tell us who you are. Did you tell us who you were in the back? No, who are you? Okay, great. Matt, Matt from Notre Dame.
Hi, thank you very much. My name is Max. I'm also an undergrad from Notre Dame.
Okay, Max from Notre Dame.
I'd like if any of you can speak a little bit more about what has international law learned from Israel-Palestine, or how has it changed as we look at whatever the next thing is 2 years, 4 years from now?
I mean, if Mary Ellen has some thoughts.
I can't resist. I love that question. I think we have learned a huge amount about how important international law is and how important it is to not abuse it for our short-term policy goals. And this is a real call to international lawyers, because I think we've let governments and leaders of groups who claim the right to use force because they are oppressed and so forth. We have to get the law right and end the interest in using excuses to get the double power of both using kinetic, violent, physical force while claiming that you're a law-abiding, good and sincere people who everyone should support. That those two are rarely correct in the same context, and I think international lawyers have prepared a ground where that is going on in too many places, in Sudan, in the Middle East, in Ukraine, in Congo. So that's the lesson that I think speaks volumes. The law is there to prevent this kind of absolutely unacceptable violence, and we international lawyers have to be right about it and keep championing it.
Just to maybe piggyback on that, I think another lesson for us is that I don't impugn you guys, need to be better at explaining the importance of law to the general public. And I mean both domestic and international law. So that just, again, elaborating, not disagreeing with anything you said, because there's a reason why lack of compliance is often understood as being in the short-term interest, right? So whether that's a general counsel of a company saying, you can't do X transaction, right? Not just because, DOJ will go after you because, well, these days probably DOJ won't, right? But that there's some intrinsic value and importance to compliance with, again, these are not sort of made up rules. These are rules that countries have agreed to. And if we give Mary Ellen a chance, I think she'll explain why she thinks that both Hamas's and Israel's use of force on October 7th and afterwards was unlawful. So I think there is room for genuine debate around the margins, but the core principles, and hopefully what we've said so far has really conveyed this, are very much a matter of common ground. Sometimes there's disagreements about facts, but the core principles, I think, are very well established. And what we see, right, when they're disregarded or when they're stretched too thinly, is that it always comes back to haunt what it is that all of us presumably are hoping for, which is just the ability to live in peace and security wherever we happen to live, right?
In a well-ordered state under the rule of law. So one of the other things we're seeing as we face a rule of law crisis in this democracy, we see a rule of law crisis in Israel, which is a democracy, earlier in Hungary, in Russia, which had for 10 years was really moving toward a real democracy. What led to the reverse? Well, when you see lawyers willing to tell governments day after day, of course you can use military force that way. We'll find a rule for you. We'll bend and shape the rules so that you can. Why is that? Why can then governments not do lesser things like fire all the workers at the Internal Revenue Service, despite what their contracts say? Why would you comply with that kind of minimal importance law if you can invade a country in 2003 and kill people? So it's a huge lesson for international lawyers about how interconnected and how fragile this idea of commitment to the rule of law is, and how with our privileged educations and ability to speak to all of you, we have to double down on just exactly what Chimène said, getting the word out that this is something that our lives depend on, our ability to flourish in an orderly society and to have the enjoyment of seeing everyone's human rights respected.
And I think, domestically in Israel, this has certainly been the line of the
Absolutely.
current government, which is courts are getting in the way of your security, right? Courts have been telling the government it can't do this, it can't do that. Similarly, right, I think the message, I think the IDF, again, historically has very much expressed a deep belief in international law. Again, maybe has made arguments that other lawyers would find a stretch, but given their circumstances, to your point, Omar, I think as you well know, I think to the extent that Israel perceived Hamas as an existential threat, it's very much because they view it as an arm of Iran, right? And so Israel's mindset still is, we are this tiny country in this sea of Muslim majority countries, some of which want us wiped off the face of the earth. Now, again, I don't think those sorts of political arguments should be able to trump the very important rules that we've all been talking about that ultimately are also the rules that shore up Israel's right to territorial sovereignty and political independence within its internationally recognized borders. But I think it is, we do need to recognize the ability of political leaders to mobilize populations, sometimes against rules of law, right? When there is a perceived, again, for lack of a better word, existential crisis. And I think for Israel, and you probably talked about this in other sessions, the other, perceived existential crisis, I mean, it's multi-layered, right? To what extent is, are secular Israelis going to remain welcome participants in a state where the ultra-Orthodox are gaining more and more political power? To what extent does the current prime minister's, personal political interest in staying out of jail motivate his decisions about, which parties are being led into the coalition? And so all of these things are interconnected, none of which is to sort of excuse or justify what's currently happening. But I think it is important to understand on both sides that sort of deep-seated psychology that allows these kind of arguments to to carry the day.
Do you want to add anything before we move on to another question?
No, why don't we
Okay.
continue?
There's an orange striped sweater.
Thank you very much. My name is Mente. I'm a 1L here at the law school. I'm curious about the dimensions outside of Gaza.
The-
Outside of Gaza.
Outside of Gaza.
Outside of Gaza, yes.
Well, one thing I think after October 7th, the theater of war, if you even want to call it that, seems to have expanded throughout much of the other parts of the Middle East, like Lebanon and Syria, but also into parts of the West Bank, where, from what I hear, settlements have been expanding. There's a lot more police and other military violence against the Palestinians in the West Bank, despite there being no Hamas presence there. So I'm kind of curious about what you think overall about the current situation in the West Bank, and especially I want to learn more about how international law specifically views settlers, given how, well, if you want to go back to the Northern Ireland example, there weren't more Brits flowing into Northern Ireland by the time that the peace treaty was happening, whereas I think the situation is the opposite right now, where it seems like settlements are ever expanding, even as so that's kind of one part of the question. The other part is sometimes I see like photographs, maybe they're real, maybe they're not, I don't know. But it seems like some settlers do seem to be equipped with military equipment. So I'm just wondering, what is the status of settlers in international law? Are they militants? Are they civilians? Are they somewhere in between? Is there even a category that they can be fit into in international law?
All right, well, I'll start with the first half of your question and then
Okay.
see if my colleagues want to speak to the second half. So the situation in the West Bank is worse than precarious. So since the start of this year, Israel has shifted a lot of its military operations to the West Bank. And in the context of those military operations, in three large refugee camps in Jenin and Tulkarem and Nur Shams. Some 40,000 Palestinians have been displaced from their homes. And in the words of the Director of Operations of Médecins Sans Frontières, just yesterday, those homes have now been reduced to ruins and dust. And so precisely the dynamic that we had seen in the Gaza Strip has begun to spread. Israel has carried some of that policy to the West Bank. And as my friend Darrell Lee wrote in a really great piece in the Journal of Palestine Studies a while back called Israel's Laboratory, the Gaza Strip is very often where things are tested before they are applied in the West Bank. And that related to a whole array of both military and other policies. So I'm very worried, and what makes me particularly so is not just because we see it shifting, but because if we're honest, the West Bank is what really matters to key members of Netanyahu's coalition. That is the space that for religious nationalists in the Israeli government is of preeminent importance. And some of them have argued emphatically for leveling Palestinian cities in that space, for pushing Palestinians in the West Bank to the East Bank, into Jordan, which would be catastrophic on so many levels. And so we've got to be watching really closely. And I say that with hesitation because there was a time when the phrase "all eyes on Rafah" was like a thing, and all eyes were on Rafah, and while all eyes were on it, Rafah was destroyed. And so scrutiny turns out to not be enough. The last thing I'll say is that there is a real question about what the Trump administration is going to choose to do with regard to Israel's annexation ambitions in the West Bank. I mentioned earlier this complicated jurisdictional scheme of areas A, B, and C. Area C, which is the majority of the West Bank, covers about 60%. And there's more than a small chance that Israel will seek to do there what it's done already in East Jerusalem and the Golan Heights, which is to, in its words, extend its sovereignty or annex that territory. And a real question is going to be, what reaction will the US government have to that step? And what will other states in the international system do? Because if that is done, then so much of what we have conceptualized as possible futures for Israel-Palestine become much, much harder to implement.
Yeah, I mean, I guess I'll just add that even within, well, not just even, within Israeli society, there are deep divisions. And, you know, again, the term settlers is used in different ways in different contexts. But this advisory opinion that Omar talked about in his opening remarks, although its status under international law is technically that of an advisory opinion, you know, virtually all of the justices agreed that under the law of occupation, you know, permanent settlements are unlawful, right? Settlements or you know, activities undertaken during the course of an occupation must be defensive and temporary in nature. And so we have a real problem because, as Omar said, that the facts on the ground now have been manipulated such that you've got, you know, huge populations, Jewish populations existing, and that the people, by and large, not exclusively, but the people who choose to live in those settlements are the more militant, and I'm using that in a non-technical legal sense. Mary Ellen might want to answer the question about categorization of individuals, but it really is a tinderbox, and unfortunately one that was very consciously crafted, I think, by, again, certain elements in government with the tacit, if not more, acquiescence, certainly, of past US administrations. And now, I mean, Mike Huckabee had his confirmation hearing to be ambassador to Israel, and if he's confirmed, is sort of openly and unabashedly annexationist. And again, you know, to the extent that you're looking, I think there are quite a few areas of agreement on this panel, but one of them absolutely is that acquisition of territory by use of force is patently unlawful.
What was the second half of your question?
About whether settlers are combatants or are civilians.
No, they are civilians. They are committing crimes. They're, and this is where some of my disagreement with my two colleagues. I think we go to the war category far too quickly. And it's actually one of the things we can correct just as international lawyers, to be very careful about what we're calling an armed conflict, what we're calling a right to go to war. For example, it's clear to me that the people of Palestine have the right to a state. This is the whole ethos. The main thing the UN Charter did at the end of the Second World War was to commit the world to end the scourge of armed conflict. The whole charter is devoted first and foremost to peace under international law. You talked about Article 2. I like to talk about Article 1, which says every member of the UN is committed to international law and fulfilling all their rights and duties. What's the other thing that the UN Charter does? It promotes human rights, including self-determination. It's this first great end of colonialism, and the British were moving toward their obligations to end colonialism in the former mandate of Transjordan. And that quickly disintegrated because of resort to violence. We have to get back to solving these kinds of problems through non-forceful means. And we can do that already right now by saying, no, these settlers are committing violence. That is a crime. But they are not part of an organized armed group engaging with another organized armed group. I've said this recently because our president thinks that we are at war with Venezuela. We are not. And international lawyers shouldn't just smile and say, there goes President Trump again. We have to be clear that this is intolerable, that it's not acceptable. So my great message is, no, don't call the settlers, and don't call people who use terrorism fighters or combatants. They are criminals. But that also means you cannot respond to that criminality with military force. You respond with police levels of force. This is what I believe the law already says. But even if you don't agree with me, isn't this the way we should be going forward? Where is the good for anyone involved in this 80-plus-year tragedy of using more violence of any kind? Certainly the major armed conflict kind, the 2000 bomb kind, but any kind. There will be no security for the settlers who push into the West Bank and take people's homes. They will always, and so I think we are over-focused on the US as well. We have a president who has less than 4 years left in his term. We have midterms coming. Israel is very isolated. If its ability to keep committing, violating international law is dependent on its relationship with the US, I suggest to you that that's not its best choice for going forward. This is a very tenuous position to be in, and there's no backup, right? Who's going to step in if there's a major change in Congress and they stop weapons shipments, stop the use of financing, and then a new president says, we're going to withdraw our unlawful recognition of annexed territories, and that includes in Syria. So. Please, yeah. Tell us your name. I know you're a law student. Yeah. Not just from Notre Dame, but from the Notre Dame Law School.
Guilty as charged, yes. An international law student at the,
What's your name?
my name is Erica.
Thank you.
So again, you've actually mentioned that we were focusing so much on the US. I wanted to ask a bit about what you guys think the actual realistic political will of, say, the EU is my main concern. If we were to have the International Court of Justice come out and say, yes, this is something they need to sanction for, do you think that the EU or any individual states would have major issues with that? Because within the EU, different countries have very, very different opinions on this overall. Again, Ireland is extremely pro-Palestine. Italy is extremely pro-Israel, and then again, Germany is the powerhouse, of course. And so again, you have these countries with very fraught histories and very mixed opinions, we will say, in what I think often in the U.S. we see as far too homogenous of a union. So what do you think different reactions would be across the EU, and how do you think they would react if this were to happen?
Well, I'll leave some of this to Omar. He's been spending a lot of time in France, so you might have a closer up view. To my mind, so sort of who can fill the U.S. vacuum to the extent there is a vacuum, and again, U.S. policy, has generally been pretty pro-Israel, but obviously there's different degrees, and the first Trump administration's decision to recognize sovereignty in the Golan Heights, was sort of a prefigured what may happen during this administration. So while at the same time, mind you, the United States, up until a couple weeks ago, was the leading voice against Russian annexation of parts of Ukraine. So, and in fact, Senator Lindsey Graham was very complimentary of the International Criminal Court's decision to pursue Vladimir Putin. So, so I think that each individual country, as you said, has its own domestic political composition that manifests itself in different foreign policy positions. I think some of the countries you mentioned also have internal legal processes where under either the Arms Trade Treaty or legislation implementing the Arms Trade Treaty, there have been challenges to things like arms transfers to Israel because of this idea. There's actually a lawsuit also in the International Court of Justice that has not resulted in provisional measures, but is still there against Germany, for example, for supplying weapons on the theory that this amounts to complicity in what could be genocidal acts, right? So all of these methods are being deployed. And then the question is, in international law, we have often relied, not exclusively, but largely on the idea that countries seek to preserve their reputations as law-abiding members of the international community. And I think, again, that has been a strong driver of many countries' conduct. I do think we see that breaking down. And so this is a concern that we collectively have, where a lot of the incentives, right? So maybe not concrete political incentives like you were talking about, sort of what's the backstop, but more generally, incentives to be, no one forced Israel to show up, as you said, in those preliminary measures hearings, but Israel did, and it presented its argument, and it explained why, it was aghast at the notion that it could be accused of genocide, having been sort of on the receiving end, essentially, or its people having been on the receiving end of kind of the atrocities that gave rise to the very coining of the term, right? But it participated. And so I think this sort of, where is the buy-in, and what is the story that we tell, and what is the story that we're hearing? We heard earlier about journalists, right, who have a critical role in finding out and reporting facts, but the extent to which those facts are actually making it through to various affected populations is unclear. So I feel like our ability to act collectively is being seriously challenged. And nonetheless, and again, I'll let you talk about the EU specifically, but nonetheless, we have seen General Assembly resolutions adopted by wide margins. The Security Council is really where the paralysis is, and that's problematic because under the UN Charter, that's primarily the body that is given the real authority to act, the teeth, so to speak, right? But the General Assembly is, I think, can be a much more powerful body than it has been, and this will be where we sort of see changes to international law. Someone was asking about the effect on international law of all of this. I think the General Assembly has been stepping up to fill some of the void.
There are so many factors in play, so it's hard to prognosticate, but I think it's useful to maybe name some of the factors. And so one of the factors is where domestic constituencies are in each of these countries in relation to Israel-Palestine. As you pointed out, we've got a big difference, for example, between Ireland on the one hand on that front and Germany on the other. And a second question is where the political tides are aside from policy toward Israel-Palestine in general, there is a growing sort of sorting into camps. And what we have seen over the last few years is the same kind of populism that has gripped America being a significant feature in a number of states, and that fueled Brexit, but has also pushed Britain away from the Tories momentarily. We'll see how long that's going to be for. But I think one of the really big questions these days in France, where I spend a lot of time, is to what extent we'll see the Front National, which has been, the Rassemblement National, which has been very explicitly pro-Israel, despite its anti-Semitic origins, where it will go. And interestingly, what I'm hearing these days is apprehension about where the US is heading seems to be dampening enthusiasm for the far right in France. And so, where things will go on that front, I think is significant. And then a third factor is the attitudes in each of these places about the European Union as a project. And I think that we are seeing real divergences. And it's long been a dimension with, states like Hungary, for example, and Poland, sort of setting out in their own direction and blocking collective action. But I think this is a really major dynamic now. I'll stop.
And if you're interested in democracy, the Kroc Institute will have a fabulous speaker from Harvard tomorrow speaking on the the future of democracy. So come for that. But right now, we have to hear from our other wonderful colleague to bring this great session to a close.
Great, yes, and let me just take a step back. Lawyers get a bad rap. I think, right, it's the only profession where everyone can tell a joke at its expense. But when you go to law school, as I did in a previous life, you learn to appreciate the great nobility of the law. To be committed to the law is to be committed to governance by means of rules and by means of reasoned debate about those rules. This doesn't mean to renounce passion or moral intensity. We're speaking rather of a passionate commitment to rules that embody moral principles. Our two visitors, Professor Omar Dajani, Professor Chimène Keitner, and our moderator, Professor Marion O'Connell, they've manifested that commitment to us here in the arena of Israel-Palestine, and I'll ask you to join me in thanking them for this.